Hey, deputy, bring her back in here. Deputy,
Yeah. What is it?
you have something you want to say to me?
Not to you. No. No, sir.
You were in my courtroom. I
was walking away from your courtroom is what I was doing.
Ma'am?
I'm so tired of this system fucking me over is what I'm tired of doing.
This is case number 25CR43210, the state of Ohio versus Rebecca Curtis. You are Rebecca Curtis?
Yes, sir.
Ms. Nicholson is here on behalf of the state of Ohio. Can you tell me when she is scheduled to be in front of grand jury?
Her indictment was issued this morning.
She was indicted this morning.
So I do have a copy of that I can serve her with. It is for 2 counts of assault on a police officer, felonies of the 4th degree, the 1 count of obstructing official business, a felony of the 5th degree, a misdemeanor 1 resisting arrest, and a misdemeanor 4 criminal trespass.
Okay.
The record, she has been handed a copy.
Thank you.
And Your Honor, we do have an arraignment entry if the court wants to arraign her today.
No.
Or it's set for next week.
Yeah, she can just wait.
Okay.
Yeah, it's, she was just served, so she's got 24 hours. She might as well just set it for next week. Ms. Curtis, it's somewhat unusual for me to schedule this for hearing. Since I did not set your bond, I did not revoke your bond. Usually I only set these for hearing if I revoked your bond from the lower court. Tell me why I should modify this bond.
Well, I'm just trying to be home for the holidays, really, if I can.
Officer, you have any information about this at all?
Your Honor, she was booked into the jail on the 25th. She'll have 25 days credit. I spoke with her over the phone yesterday and put all that information in the bond report. She provided a Middletown address. She reported she stays there a few days off and on, and then goes and stays at motels often. Reported she's not employed, that she's unable to get employment due to having cirrhosis and her mental health. And then she reported that she's currently in treatment with Butler Behavioral Health for PTSD, battered woman syndrome, human trafficking victim, but I was unable to verify that.
Got quite the record, Miss Curtis. Dating all the way back to 2008. I'm sorry. Goes on. I'm sorry, what keeps going on? 2002. Who do you live with?
My daughter.
The state have a request for bond?
Your Honor, this occurred at the Motel 75 back in November. So I don't know if it appeared that she was living there at the time. You know, I know I read in her letter that it indicated that she was in treatment, but alarming that this set of facts occurs while she is in treatment. Additionally, she was sentenced to prison in January for an ILC after an ILC violation, and was released about 4 months prior to this offense. She has a history of community control violations and not following orders given to her by the court. So I think if the court is inclined to release her, I mean, her bond is $100,000, 10%. If the court is inclined to modify that or to release her, we would ask that she be placed on electronically monitored house arrest. It sounds like she doesn't, I don't know how stable her living arrangements are. She does have a lengthy history.
Ms. Curtis, you were granted ILC by me in December of 24, so 1 year ago. Within a few weeks of that, you refused to go to the CBCF that I ordered. So I'm guessing you just wanted to continue to use illegal drugs.
That's your assumption, but I can drop urine and it's clean. I go to.
Well, you've been in jail for the last 30 days. I certainly hope that you'll be clean.
Oh yes, but I'm saying prior to that, you can
Yeah.
discuss it with Butler Behavior if you need to. I'm still going there.
Well, since you're going to be arraigned on Wednesday, at this point in time, the court's not going to modify the current bond order. I'll let the you can make a pitch to the magistrates when they arraign you next week. All right, that's all. Hey, deputy, bring her back in here. Deputy!
Yeah. What is it?
You have something you want to say to me?
Not you, no. No, sir.
You were in my courtroom. I don't.
I was walking away from your courtroom,
were
is what I
still-
was doing.
Ma'am?
I'm so tired of this system fucking me over is what I'm tired of doing. I really am, sir. It's not you directly, it's somebody else in this system. I
But when you
appreciate
were-
you, I respect you, but I am not gonna keep letting this shit happen to me. I'm not. And other people. It's not you, it's somebody else in this system. That's all I'm saying. No disrespect to you. Have a nice holiday.
I am disrespected because when you use that kind of language in my courtroom, whether
Well,
you-
when I get mistreated by the system, you'd feel the same way, sir.
All right.
No disrespect to you personally.
But it
It's
is.
somebody else. Thank you, sir. I have her freedom of speech, you know? Like I said, fuck 'em.
What we see here is a pattern the court cannot ignore. This hearing was never just about bond or timing. It was about credibility, accountability, and history. The judge didn't react to emotion. He reacted to a record. Years of arrests, repeated violations, failed treatment opportunities, and a pattern of defiance placed this defendant squarely where the law draws its line. And yet, her frustration isn't invented. Many defendants genuinely feel overwhelmed by a system that moves slowly, punishes repeatedly, and rarely feels personal. To someone trapped in cycles of addiction, instability, and prior convictions, the court can feel less like justice and more like a wall that never moves. That perception explains the anger, but it doesn't excuse the conduct. Legally, the court's duty is not to validate feelings. It is to assess risk. Here, the judge weighed community safety, the defendant's documented non-compliance, and the timing of new charges so close to prior release. Under those facts, bond modification was not a question of mercy. It was a question of public protection. This ruling reinforces a core principle of criminal law. Accountability comes before relief. The system offers chances, but it does not offer endless resets. At some point, consequences are no longer optional. They are necessary.